Welcome to my channel. This is my first video that I will be doing on YouTube. I chose the topic on business trust, specifically American Jurisprudence, with a second edition, volume 13. I want to thank Island Girl for sending me this PDF. It's 164 pages. This is just part one. I'm guessing maybe 5 or more, depending on how many pages I get through it. So, to start, the scope of the topic. This article considers the business or Massachusetts trust an organization created voluntarily by a trust instrument whereby trustees manage the trust estate for the benefit of holders of transferable certificates, representing their proportionate interest and rights in the proceeds and the corpus of a trust estate. Matters treated include the creation, organization, and duration of a business trust, the nature, attributes, and liability of the trust estate, shareholders, members, and sesquiu trustant, which just means beneficiaries, and all their rights, shares, and liabilities, trustees, officers, and agents of such a trust and their powers, rights, and liabilities, taxation and governmental regulation of business trust, the termination, dissolution, reorganization, and merger of such trust, and practice and procedure in cases involving business trust insofar as peculiarly relevant or distinctively applied to such trust. Section 1 is definitions and terminology. One of the distinctive devices by means of which individuals may combine their resources to operate a business for profit in the so-called business trust or Massachusetts trust, which may be comprehensively defined as an unincorporated business organization created by an instrument by which property is to be held and managed by trustees for the benefit and profit of such persons as may be or may become holders of transferable certificates evidencing the beneficial interest in this trust estate. Such an organization has also been frequently termed a common law trust, but this phrase is not descriptive of any of the particular characteristics of such organizations. Business trusts are excluded from the coverage of the restatement of the law of trust, which really only applies to ordinary trust, wherein it is pointed out that the business trust is a special kind of business association and can best be dealt with in connection with other business associations. Under the Uniform Commercial Code, the term organization, unless the context otherwise requires, is defined to include business trust. But even though restatement of the law of trust is for ordinary trust and resulting trust and so forth, the principles are still the same. The principles that apply to both. But because this is about holding property and maintaining it for some period, where the other one is about business. So they're separated and they're in their own class. These annotations are good, which I highly encourage people to read. To read a couple, I will read. A trust of this nature is created when several persons transfer the legal title in property to trustees with power vested in the latter to manage and control the property and business and to pay the profits of the enterprise to the creators of the trust or their successors in interest. And that's Goldman versus Allman. So Goldman versus Allman and Heck versus Malley are like the first real cases to where the courts are hearing this type of entity. This is after the investigation by the Commissioner of Massachusetts. Here's another one too. Schumann versus Hike is another one I highly consider that be read. The basis for the terminology common law trust in this connection is not that such organizations are the creatures of the common law, as distinguished from equity, but that they are created under the common law of contract. So it's created by your right and do not depend on any statute. it's not the common law that recognizes its equity. So common law is a misnomer only to the extent that it's a common law right to create such an entity. It says, wherein it is further explained that although many of the rules applicable to trust are applied to business trust, yet many of the rules are not applied, and there are other rules which are applicable only to business trust, which is true, because specific ones would be business-wise. It is appropriate to treat business. It is appropriate to treat business trust on a somewhat different basis than private trust. Section 2. Origin and development of business trust. The application of trust principles to the conduct of commercial enterprise is to have originated in Massachusetts as a result of inability to secure corporate charters for acquiring and developing real estate without a special act of the legislator. It also has been said that the type of organization commonly denominated Massachusetts Trust originated because of the hostility of some states toward corporations and out of a desire to secure some of the advantages of incorporation without incurring the burdens and restrictions thereto. In any event, the Massachusetts Trust has reached its fullest development and use in that state. The jurisprudence on the subject has grown up in comparatively recent years. This is written. That court cases like 1930, so recent years is within the last 20, 30 years, their time. Although the law reports contain several instances of the use of this form of commercial enterprise more than a century ago. So you're talking about 1840s, 1830s. You know, the Standard Oil Trust was 1880s and was adjudicated in early 1900s. Many large and well-known concerns, which means business, have carried on their businesses under this form of organization, and it is interesting to note that the popular use of the term trust in connection with monopolies and combinations in restraint of trade is traceable to the employment of the business trust form of organization by some of the best known of such combinations. Footnotes ain't worth mentioning there. Section 3. Nature and attributes. The distinctive features of the business trust are indicated in the definition thereof. It is unincorporated, although for the purposes of regulatory statutes or by express statutory inclusion, it is sometimes treated as a corporation for certain purposes. It is created by the voluntary act of the parties and is based on contract. It is intended for the purpose of carrying on some kind of business for commercial activity for profit. Indeed, the profit-making function is one of the most significant characteristics of the business trust. Thus, to the capital of the organization is vested in trustees who usually manage, which is a key word here, manage the affairs of the trust. The beneficial interest in the trust estate and in the profits are evidenced by transferable certificates, similar to corporate shares, and the existence or life of the organization is not affected by the death or disability of a member or shareholder, or by the sale or transfer of his interest. Basically, a business trust has been said to be merely the application of an ordinary trust for the purpose of operating a commercial enterprise. When an express trust is so used, it is known as a business trust. Accordingly, equitable principles governing trust estates generally underlie business trust as well, although business trust and ordinary trust are not always governed by the same principles, and in some respects business trusts closely resemble both partnerships and corporations. Aside from any question of mere terminology, some courts treat business trusts as partnerships for the purpose of determining the liability of shareholders for the debts of the trust. However, regardless of this similarity to a ordinary trust, to a partnership, and to a corporation, the general opinion is that the business trust should be regarded as sui generis, meaning its own creation, its own line, right? It must be regarded It must be remembered that the nature and legal status of a business trust is not an absolute and invariable factor, but depends to a large degree upon the purpose for which the inquiry is made, upon the direction from which the matter is approached. And it has been said that the character of such a trust is to be determined from the trust instrument. The essential nature of a business trust is not affected by the smallness of the number of participants, nor by the limited scope of its business. See some annotations for that section. Because a new use is being made of the trust does not mean new principles of law are to be applied in determining the rights of the trustees, the beneficiaries, or persons dealing with the trustees, and that's the Schumann case. It has been said that a business trust is a hybrid in nature, savoring of both corporation and partnership. A business trust is a distinct form of organization which, for some purposes, must be differentiated from both ordinary partnerships and corporations. Section 4. As a legal entity. There is a difference of opinion on the question whether a Massachusetts or business trust is a distinct legal entity. Some courts answer the question in the affirmative, and some statutes designate or recognize the organization as a distinct legal entity. A business trust may, under the Bankruptcy Act, be adjudicated a bankrupt on a voluntary or involuntary petition. So if you guys don't understand this, right, they're saying some courts, right, and some statutes. So they're saying in different states. But this last one says the Bankruptcy Act. That's federal. So here they're telling you some states recognize it and some don't, right? And here they're telling you that the federal recognizes that. For this purpose at least. But we know in damn near every other purpose as well. Other courts, and sometimes the same courts in other decisions, have taken the view that a business trust is not a distinct legal entity, even where a statute permits maintenance of an action at law against a business trust. But even in a jurisdiction so holding, it has been held that where trustees of a business trust, pursuant to their authority under the instrument, because it's a contract, adopt a trust name. So they don't recognize the trust as an entity, but they recognize the contract taking on a name and then doing business under that name. As a conditional sales contract is assigned to them in that name. The assignment is not made to a non-entity, but is effectively made to the trustees in the name under which they have chosen to do business. And they, in their capacity as trustees, may bring an action to recover damages for the breach of a contract. That says, like, that's big right there. It has, see, some annotations. A business trust has been said to be a quasi-legal entity, separate and distinct from the members who compose it. A common law trust association has been held to be capable of taking and holding title of to property so as to support a conviction of its employee for embezzlement. So that's another statute or whatever that they were able to fall under or apply. A statute attributing to a business trust association and characteristics of a legal or corporate entity does not involve any unconstitutional impairment of the obligation of contract. It has been suggested that a statute specifically authorizing unincorporated associations enacted subsequent to decisions holding business trusts not as corporations recognizes the business trust as a legal entity. So this is, telling you that what we know is true, right? But here's something good to understand. Business trusts are not entities apart from their trustees. right? So if you understand that it is a contract and under a name that you're functioning, right? But it's created in the construct of a trust, then you will understand that here, what they're telling you here, business trusts are not entities apart from the trustees, right? Such a trust has no legal existence apart from its trustees, so far as the concerns of the right of contracting parties to recover on a contract made in the name of the trust. Other than for purposes of being sued, a business trust is not a legal entity because it's all about the contract. It's the trust, the duty that they have, the powers that they were given in the contract. Section 5. Advantages and disadvantages of business trust form of organization. As compared with other forms of commercial enterprise, the business trust exhibits certain advantages which have made it an attractive means of conducting a business. From the great body of equity jurisprudence relating to trust, it derives the heritage of flexibility and adaptability and of direct action and personal responsibility on the part of the trustees, being created by the act of the parties and governed by the terms of their agreement. A business trust is as general and as elastic as a contract. The latitude of the powers and activities of the trustees of a business trust is greater than that of ordinary trustees. Founded in equity, a business trust enjoys the advantage that the trustee may avail himself of one of the few exceptions to the general principle that the courts will not declare future rights, and he may apply to a court of equity for directions in the execution of the trust, or maintain a suit for a declaratory judgment to establish the meaning and intent of the trust. So this right here is literally stating, right, you as one of the principles of equity, you have the power to go to a court, meaning yes, conferring jurisdiction, right, to the extent that they are interpreting this thing, the contract that you made, for interpretation. You're asking it questions, right? Why is this important? Because if it has to be done 20 years after you're dead, well, they don't know who you are, those people, for the most part. So your intentions are only with one person, and that was you. So the more paperwork and more opinions and things that you write of that nature in regards to your creation, your intent could be well understood by other people in the future. One of the objects of business trust is to obtain for the associates most of the advantages of corporations without the authority of any legal act and with freedom from the restrictions and regulations generally imposed by law upon corporations, where their aims can be realized. The business trust enjoys a definite advantage over the corporation. However, for a number of years there has been a tendency to subject business trust to the same regulations and taxes or exactions as are imposed upon corporations. But although the advantages enjoyed by such trust in these respects are not so pronounced as formerly, they still occupy in some states a more favorable position than do corporations with respect to taxation and statutory regulations. And in some instances, the shareholders of a business trust enjoy an even greater immunity from personal liability than is accorded to stockholders of corporations. The principal advantages which the business trust has over partnerships are its centralized management, the introduction of large numbers of participants, the possibility of transferable beneficial interests without affecting the continuity of the enterprise, the fact that the death or disability of a shareholder does not terminate the trust, and the immunity of shareholders from personal liability under some conditions. On the other hand, the possible liability of shareholders is a serious disadvantage of business trusts in some jurisdictions. In many states, the shareholders are personally liable as partners for debts of the trust, where the trust instrument vests them with the power of control over the trustees in the management of the affairs of the trust. However, in most states, the parties may avoid liability by vesting in the trustees the exclusive management of the business, free from the control of the shareholders, at least where the trust instrument specifically exempts them from personal liability. This is important, right? Earlier I was said the word usually, right? Because why? It's usually, it only happens if the beneficiary have control. If they don't have control, and the trustees are, you know what I'm saying, and you know, you're looking for just issues. Like, you got to have the trustees in full control whatsoever. They can't. And in all jurisdictions, they may effectively guard against liability by agreement with creditors, as by making their personal immunity a condition of the contract or obligation. So this is you, as a trustee, writing down the provision in your contract, with whoever you're contracting with, that the beneficiaries, as well as yourself as trustee, not to be held liable. And it's the trust estate that's held liable for any deeds, misgiving, or mistakes that you do in life for the trust that end up costing money. The chief advantage of this form of organization are their comparative freedom from regulation and from corporation taxation, freedom of the members from the personal liability which is imposed upon partners, and the fact that the trust does not dissolve as does a partnership upon the transfer of a sale of a share or upon the death, insanity, or bankruptcy of a member. Section 6. Validity of and efficacy as business trust. It says, broadly speaking, business trusts are regarded as legal and valid, at least in the sense that such organizations are not, by reason of their nature, which is a contract, illegal, or contrary to public policy. While business trusts are subject to the general principles of law governing the legality of contracts and trusts, and must conform with the public policy of the states in all particular, a court will not declare such trust void unless impelled to do so by clear and firmly established principles. It has been held that public policy is not offended by permitting a business to be carried on by trustees who limit their liability to the trust estate, nor under the prevailing view do statutes authorizing limited liability partnerships and corporations by implication prohibit the creation of other types of organizations, such as business trusts, enjoying similar immunity by virtue of the common law. And of course not. You know, they made a statute that benefits them, but just because they made one for them doesn't mean that we can't enjoy some type of benefit like that of immunity. Anyway, immunity, right, where you are when you are indemnifying someone, right, like insurance, right? Insurance is just an indemnification contract. That's all it is. The business of insurance is what they govern, but a contract, right, a private one, is not governed by by regulation, or by it's not owned by them. When I say own and govern, those are two different things. Own means we gave it to them in the Constitution. Regulate meaning it's based on safety and commercial law and other crap, right? So have a better understanding of that. A business trust is not valid because there was no compliance with the statutes relating to incorporation. Does that mean they'll let you participate? Who knows? It all depends on the nature of the business that you're trying to do, right? If it belongs to them, if it owns them, they could probably force you to be incorporated. But if it doesn't, then no. Nor does such a trust violate any policy evidenced by statutes of this kind. The motive in reforming such a trust is generally not considered by the courts in determining validity, and it has been held that a business trust is not rendered illegal because of the fact that it was formed for the express purpose of reducing or avoiding taxation. So there you go. Express purpose of reducing or avoiding taxation. Such an organization will not be condemned as an attempt to take advantage of the corporate immunities without assuming the burdens and obligations connected with corporations. Properly speaking, the retention by the shareholders of the power of control over trustees does not have the effect of invalidating the trust, regardless of other consequences. So, this is if beneficiaries have control, right, over trustees. It doesn't change the validity that it is a contract, it is a trust. It might have other consequences, but that don't change the validity. The fact that persons appointed as trustees are shareholders in a trust does not affect the validity of the trust. However, it has been held that there can be no valid business trust, at least for the purpose of exempting the shareholders from personal liability, where all the shareholders are trustees and the trustees and shareholders are identical persons. Although the organization might subsequently become valid when persons other than the trustees become shareholders. So, like, if they're the same people on both sides, get a new shareholder, now your stuff is valid again. You know, when you everyone's holding the same titles, both legal and beneficial, in equal amounts, right? Dude, you just terminated your own trust. It's not valid. You gotta bifurcate the title by adding one person or taking away one person to either side of the line. In no jurisdiction are business trusts as such held to be totally invalid, in the sense that no effect whatever will be given to the trust instrument, and the parties will be treated as strangers. However, the courts frequently deal in terms of validity with the question whether a business trust has achieved a particular purpose, such as to insulate shareholders from personal liability or to obtain corporate advantages without a corporate burdens, or the like. In some few jurisdictions, an organization in the form of a business trust is regarded as a corporation or as a partnership for the purpose of determining the individual liability of shareholders, or as a company or association for the purposes of the Blue Sky Law. Under yet another view, the conduct of business by a business trust which has neither incorporated nor complied with the laws applicable to trust companies is held to be an unlawful usurpation of corporate powers by the trustees. So what does they mean here? This is you doing some business that belongs to them, meaning conferred by some constitution. So you're doing business within their house, and their requirement is you need to be incorporated. By you not doing so, you are stealing, you are usurpating their powers, their corporate powers specifically. However, only a state can complain of such unlawful assumption of corporate powers, corporate functions, and at least as between the members and parties of the trust instrument, the courts will give effect to the provisions thereof according to the principles of contract law, which should be a given. Contract law is what governs, not statutes. The conclusion that business trusts are generally valid is reached more readily when such trusts are recognized as valid by legislative act. A statute of Oklahoma expressly authorizes the creation of a trust to carry on and conduct any lawful business designated in the instrument of trust, and generally do so any lawful act in relation to such trust property, which any individual owning the same absolutely might do. I'll let you guys read these annotations. Texas is rough though. In Texas, the view is held that a business trust is, at least in relation to outsiders, I'm guessing foreign business trust, right? In effect, a partnership, so that provisions of the trust instrument purporting to limit liability of the shareholders for debts of the trust are of no effect. So whatever that case applied to, I would read if you're in Texas. However, you gotta understand the context of why that's being said. However, as between the parties to a trust agreement, it appears that the trust relationship will be recognized. That's another Texan case. Declaring a common law trust or business trust to be a corporation does not deprive anyone of property without due process or deny to anyone the equal protection of the law. Well, can't, right? Because your activities ultimately are what's going to construe you as a corporation. You could write it up as neatly as you want, that indenture. But if your activities show otherwise, your positions, right, and the powers and whatever tied to them, wherein the court said that as between the members of the trustees, the trust instrument presents simply a question of contract, augmented by the question of agency, to be determined by the rules pertaining to those subjects, and the intention of the parties as expressed in the instrument will govern. Section 7. What laws govern? It is generally held that an instrument creating a business or Massachusetts trust should be construed by the law of the state where the trust was organized, and a statute of a state in which a trust was organized authorizing suit and attachment against such a trust and providing a specific manner for service has been held to be applicable in an action in another state, and failure to comply with the stipulated method of service of process has been held to confer on the court of the forum state no jurisdiction of an action against a business trust. On the other hand, the fact that by the law of the state where the business trust was organized, it would not be treated as a corporation for the purpose of service of process has been held not to prevent the application of the local statute authorizing service on a trust as a foreign corporation. The reason why is because the law of where you're created at is what governs. So in that case, the law where he was created at didn't allow for that statute in another state to apply to it. The law of the state wherein the business trust was organized will not be applied to produce a result contravening the public policy of a forum state. Right? So you can't violate the forum state. Accordingly, courts have refused to, as violative of public policy of a forum state, to give effect to provisions of trust instruments executed in other states purporting to exempt shareholders from personal liability for the debts of the trust. It has been held otherwise, however, where the state in the forum had no settled law on the subject. Now this right here is public policy, right? Where they hold shareholders ultimately liable. But up here, this was not, right? They're talking in such a way that it is not. It all depends on the context of what the action is, what it is. The property, like I said, if you're using their stuff. It has been held that the validity of a business trust and the property of which consists the personality, which is personal property, it is to be determined by the law of the domicile of the grantor, of persons creating the trust, and that if the trust is valid there, it is valid everywhere. This is especially so where the trust instrument expressly provides that the rights and duties of the parties are to be determined according to the laws of the state of their domicile. Now, why is there a difference here, right? It's because personal property is not real property. Government has an interest in real property, whether real estate or land, right? They have no interest in your personal property. The only time they can potentially is when you introduce it into some business or something where you're putting it into work, into that it needs to be regulated. So to that extent, that's it. The next section, this is the law supplement. Massachusetts law was applicable to a business trust organized and existing under the laws of Massachusetts, where the declaration of trust with which the shareholders became associated only by voluntary choice on the part of each of them, expressly provided that the law of Massachusetts should be the applicable law as to the rights of all parties. So they're putting it in there. They put it in their indenture. Notwithstanding the existence of substantial contacts between Massachusetts Business Trust and the state of New York. So even though there's a substantial minimum context between that business and New York, where the Declaration of Trust contained provision whereby parties agreed that their rights under the trust were to be governed by Massachusetts law. Shareholders had right to rely on the terms of the declaration, and therefore it was appropriate to apply Massachusetts law to determine inter alia whether a complaint in shareholders' derivative action was insufficient in filing to allege a demand on trustees and shareholders. I mean, a lot of this speaks for itself. And annotations, the character of a business trust organized in another state will be determined for the purposes of suit against it by the law of the state where it was organized and not by the law of the forum. Refusing to apply the law of Texas, which ordinarily would have been applicable, by which the shareholders of a business trust are held liable for as partners, notwithstanding provisions in the trust instrument expressly negating such liability, since this view was fundamentally contrary to a well-established rule of the forum that the existence of partnerships depend on an agreement, express or implied, for mutual liability for losses, and that such liability cannot exist where, as such, there is an express stipulation against it. The established public policy of the forum is supreme, and will not be relaxed upon the ground of comity to enforce contracts which contravene the policy, even though such contracts are valid were made. Holding that the law of Massachusetts, where the trust was organized, governed the construction of the trust instrument for the purpose of determining the liability of shareholders for the torts of the trust. And the next section is actually part B, and it's going to be section 8, and this is going to be for other organizations and relationships compared and distinguished. This will be for the next video. This will be part 2. So this is the comparison between what a corporation and a partnership and so forth and any other entity that might be similar to a business trust, which is important. So hopefully you guys enjoyed the video, and you'll want to listen in on the next one. Have a good night. Okay, I finished it. Hold on. I'm stopping. You know what I didn't do? I didn't share